Fox Oldies, 98.9, 105.3, WGNY FM in New York. A fun day Saturday morning. I'm Bobo, and with me right now, a special guest, and I've been promising you this all morning, our little segment of Planning Ahead with our mega eldercare attorney, Megan. Good morning.
Good morning, Bobo. So happy to be here.
Yeah, what an intro, huh?
That was a great one. I appreciate it.
See, that's why I make the big bucks, Megan. It's so great having you aboard.
Same here. How are you? How have you been?
The weather is just all wrong. It's too cold.
I know. I feel like all year we say we can't wait for the winter and the holidays, and then as soon as the holidays end, we're saying, okay, back to summer, please.
That's enough. Let me up. Yeah, exactly. Megan, so right off the bat with Planning Ahead, give us all your contact information.
Absolutely. I'm a partner at the law firm of Blustein, Shapiro, Frank, and Barone. We're located primarily in Goshen. The phone number for the office is 845-291-0011. We also have a really good website. It's www.mid-hudsonlaw.com.
All right. Didn't recently you just have a workshop?
I did. I had a virtual workshop in January. It was live, but hosted by Zoom. And then our next one is going to be on March 11th. That one will be in person, weather permitting, of course.
Yeah, right. And people need to RSVP this?
Yes, especially for the in-person workshops. Because we host them here at the office, there's very limited seating. So we try to accommodate as many people as we can, but it's first come, first serve. So if anyone wants to sign up, those workshops are free and available to the public. They can sign up through the website or by calling the office.
I think that's a great deed that you do. I really, really do. Giving people a heads up on things that they need to know. All right. Megan, so let me ask you this with our Planning Ahead segment here this morning. This is an interesting question. And the question is, how can you or even can you avoid probate?
That's a great question. And a lot of times when I meet with clients for the first time and I inquire about what some of their goals are, that's something they're telling me they want to do. They want to avoid probate if at all possible. Now, a lot of times it's because people don't really understand what probate is. You and I have discussed probate and that process several times, but the very short version is that it's the court overseeing the distribution of my assets after I pass away. And they either do that by reviewing my will, so they see what my instructions were and then make sure my executor carries out those wishes. Or if I didn't have a will, they refer to the state statute to see who my beneficiaries of my estate should be. And a lot of times when people hear probate, they think it's something really bad, but really all that's happening is the court is ensuring that the right people are receiving the right assets. But there's some downside to that. So anytime we're dealing with court, we're often dealing with some additional expense, definitely some delays, and then there can be more complicated processes associated. So if there was debt owed or creditors or disinherited individuals, now we're really getting into the potential for a lot more expense and contest. So when people are asking me to avoid probate, they're looking to avoid that extended distribution process going through the court. But what they don't realize is that the court oversees the distribution of what I'm going to call individually titled assets only, meaning if I had the Megan Conroy bank account at our local bank and I never added a joint owner and I never added a beneficiary to that account and then I pass away, that asset is one that the court would oversee. So some kind of neat trick that we can use to avoid probate is to make sure we don't leave any assets that are individually titled, meaning without a joint owner and without a beneficiary.
So
following so far?
I think so. maybe you already answered the question, but how would someone like myself avoid probate?
Absolutely. So what you would want to do is take a look at your assets. I think that's a really good first step for people that are thinking they want to tackle estate planning this year. One thing that's going to become really important as part of the planning process is knowing what assets you have, what financial institutions they're located at, right? So if I have a checking account at our local banking institution, and then I have a retirement account through my job and maybe life insurance I bought years ago, I should really compile a list of all of those assets, absolutely everything I still own. And then what I want to do is check for each of those assets to see, am I listed as the only owner? If I am, do I have a beneficiary designated on the account? A really easy way to make sure that we're avoiding probate is by making sure that we have proper beneficiaries designated on any assets that we can designate beneficiaries on. And here in New York, you can pretty much put a beneficiary on almost any kind of an asset. So vehicles would be an exclusion to that. New York does actually allow you to put a beneficiary on your home, on real estate, although there can be some issues associated with that, which I won't get into today, but certainly a topic for another time.
Right.
But you can put a beneficiary on regular checking account, savings account, CD, money market brokerage, stocks, bonds, insurance, and retirement. And that would be a really good way to make sure we're avoiding probate, because when we have a beneficiary, it means that that asset will pass directly to the designated beneficiary when I die, and the court doesn't have to oversee the process. So we've now effectively cut out the middleman. We cut out probate.
Oh. Well, let me ask you this. Why not vehicles?
I'm not sure why New York State, and maybe it's not even unique to New York, but I'm not sure why we can't designate a beneficiary on a vehicle. I don't believe that that's an option when you look at your title to put a beneficiary on there. But with vehicles in New York, there's actually a sort of tricky exclusion. A family member of a deceased individual can, using DMV forms, actually transfer the deceased vehicle to themselves as long as they're only using it for one vehicle, so we can't do it for several vehicles, but just one, and we can say that the value of the vehicle is $25,000 or less. So sometimes when a family comes to me after their loved one passes away, and we determine that the only asset that was left with no joint owner and no beneficiary was the vehicle, we can actually use those DMV forms to get that transferred. And now I know no one likes to deal with the DMV. They've gotten a lot better. You can make appointments, and I highly recommend you do that. But going through the DMV and using their forms there is a fair bit easier than going through the probate process.
Even if it's a classic car that's worth $100,000?
So because the vehicle in that example is worth over $25,000, you can't use the DMV forms for that. So for that kind of a vehicle, you would have to go through probate.
Oh, there's the old catch-a-rooney.
Mm-hmm.
Okay. So saying that if someone passed away and they had a 1966 Corvette Coupe that was worth over $100,000, there's no way you could avoid probate with that then. Is that what you're saying?
Well, it's not that there's no way. It's just not as easy. So it's really going to depend on the circumstances. If that vehicle is one that is registered, let's say, between husband and wife, and husband passes away, because the wife is still on the title, I don't know if the 66, if that has a title or a registration technically, but if the wife is associated with the ownership of the vehicle, either through title or the old cars, I think just do a registration, then because the wife is the survivor and she was an owner, she just continues to own the vehicle. So now she didn't have to go through probate. But if then the wife passes away and she never added any additional owners to that vehicle, then her family members or whoever she leaves behind, they would then have to go through probate. So jointly titled assets won't go through probate. So for something like a vehicle, maybe we want to have that titled jointly between spouses. But then if there's no surviving joint owner, at that time we're going to see the probate proceeding take precedence.
Wow. Wow. So if there is no other owner except for the deceased, and it's mentioned in his or her last will and testament, that's the way it's got to go down, right?
That's right. So when we have no surviving owners left on the asset and there are no beneficiaries designated, then that's when the will comes into play. And the will works to tell the world, tell the court, where those assets should go. But in order for a will to be effective, it has to be submitted to a court for review and approval first. And that process of submitting the will to the court, that is the probate process. So for most people, it's not the end of the world to go through probate. It's not that big a deal. However, if you wanted some simple tricks to avoid probate, we're going to look to how the asset is owned. Was there a surviving joint owner? And or is there a beneficiary designated on that asset? Those two types of ownership will avoid probate.
About how long does all that normally take, Megan?
So we like to estimate that the probate process typically takes about a year from start to finish. And that's one of the reasons people would prefer to avoid it. Whereas jointly titled assets, because they stay with the surviving owner by operation of law, it's automatic. Upon the death of the first owner, the surviving owner, or maybe there's multiple owners, just continues to own the asset. So no delay there. And then for beneficiary designation, it takes a little longer than joint ownership, but usually just a matter of a couple of weeks. Often, let's say I have a life insurance policy and I designate my husband as the beneficiary if I die. Often what you're going to find is my husband is going to contact the life insurance company, let them know that I've passed away. He'll receive some claims forms, usually by mail, so that's where some of the delay comes in. He'll complete the claims forms, submit them, and then the check will come to him again by mail unless he's elected for some kind of a direct deposit. So the process of mailing the paperwork back and forth generally takes a couple of weeks, but it's a lot faster than the probate proceeding.
Boy, I'll say, that's for sure. Because a lot of people in today's times, and you know this, are in a hurry. Like they wanted it yesterday. Don't you find that to be true?
Absolutely. Yeah, we do. We live in a society where everything is available through technology at our fingertips. We're used to receiving information very, very rapidly. And so I think that that's true with what our expectations are for almost everything we deal with. Yes.
Wow. So how to avoid probate. So that's really not all that tricky, is it?
No, it's not that tricky. I think the trickier part comes with more of an analysis as to whether I want to avoid probate or not. And so that's what the attorney is going to help with. Like I said, when I initially meet with a client and they tell me I'd like to avoid probate, we talk about the options for that. Maybe I say to them, let's just make sure that you have your spouse as primary beneficiary on all of your assets and then your children as contingent beneficiaries. And they say, okay, that's easy to do. As soon as I leave your office, I'm going to take care of that. And then I say, let's just chat a little bit further. Tell me about your kids, right? And they start to say, well, I have a daughter who's married to a guy I don't especially like. I'm a little nervous about him, and I worry that if she got an inheritance from me, she'd give it away to her husband, and she really wouldn't have any oversight, any control over the property. Or maybe they have a history of addiction, and I'm concerned that, they're doing well now, but if they got this influx of cash, they might relapse and go back to whatever addictive thing that they were doing. So if you have some concerns about your beneficiaries, that's going to lead me to start discussing some other planning options with you, because beneficiary designation doesn't provide us a great way to protect assets for our beneficiaries. If the sole goal is to avoid probate and we have no other concern, it's great. But if we have some other concerns about the people we're leaving things to, then I think some more extensive planning comes in. And so beneficiary designation and probate avoidance isn't difficult once you know how to do it, but it's probably not the end of the story for every person. Some people have greater concerns than just strictly avoiding probate.
Well, another important issue is when a client comes in to speak with you, they have to be honest. You need to know everything, do you not?
That is absolutely true. That's a great point. I can only help a person to the extent that I understand what it is they have, who we're dealing with, and what their concerns are. And if a client's not honest with me, it doesn't hurt me. I'll be disappointed if I find out, right? But certainly they're only hurting themselves because now they've come in for this consultation and they really didn't get the value of that. They didn't get the kind of advice and guidance that I could have otherwise provided if they were honest. It's very important, as you said.
You know, it kind of reminds me of someone going to the doctor, and the doctor asks, "Do you drink a lot?" "Oh, no, not me, doc." Not me. And here they are swishing down 3 quarts a week. I mean, you know,
That's right.
You gotta be honest with your doctor. I'll tell you that. I always am. And I have nobody to blame but myself. But if I want help from my doctor in prescribing the proper medications for me that I need, I have to be honest. Or, as you said, I am hurting myself.
That's right. Absolutely. And so to your point, I think the thing that people are usually not very open and honest about is going to be disclosing their assets to the attorney. And it feels invasive for some stranger to be asking you, well, how much do you have in the bank? And how much do you have in retirement? And do you have any life insurance? And we actually ask our clients to complete a questionnaire before they come in where they can write all of that information down for us. And it's uncomfortable, I'm sure, but because what we're planning for is the distribution of assets, the management of assets, I need to know about those assets to make sure that I know what kind of recommendation to make to you and what kind of problems we might encounter, right? I can't expect my client to know all of the things that I know. And so for me to be able to give them that guidance and advice, I need to see all of the asset information so that I can make the recommendations. And then ultimately, whatever the client does is up to them. You're only going to be presented with options, and then the client decides how they wish to proceed. They'll never be forced into something.
You know, with me personally, Megan, I have to be completely honest with you by letting you know I have no problem releasing that type of information to an attorney. I really seriously don't have any problem releasing that type of information to an attorney, especially if I want some great sound advice legally.
That's wonderful. And I would say that a lot of people would agree with you. It's very few people that are not willing to disclose the information. But you're right. I think just emphasizing the importance of that. In some ways, it's also about being honest with yourself, right? So if we're not so much talking about assets, but instead maybe the analysis of our family situation, I ask my clients, you know, how do you feel that your children are with making decisions? Yeah. Have they demonstrated to you that they're good at managing finances? And sometimes people will say to me, you know, I want to designate my son because he's the oldest, and then I'll designate my second child and then my third child in that order. But when I ask, is your son good at making decisions? Do they procrastinate, or are they kind of a go-getter? They'll jump right on the phone and take care of tasks. After I ask them, they start to say, you know, now that you mention it, I really hadn't thought about this. But my son, he doesn't like getting on the phone. He'd much rather order things right on an app than pick up the phone or fill out the paperwork. Yeah. Maybe he's not the best person to put in that first position. So sometimes the honesty isn't necessarily because they want to hide it from the attorney, but because they've never done that analysis themselves and they don't want to think about, maybe this child isn't great for this position. Maybe they'd be better suited for something else. So sometimes just facing that reality is tough too.
Well, see, that's what makes you such a mega attorney, because you make your clients think. And that's not a bad thing. That's a good thing, Megan.
Thank you. I appreciate that. And I do think it's a good thing. What it means is that when people come into me, right, they might expect, I'm just going to sit with the attorney for 15 minutes. She's going to fill out a will form for me and I'll be on my way. But as you know,
Oh, yeah.
the process is not that way. If I'm trying to get you to think it's going to occur over several hours of conversation, but it's for the client, right? Ultimately, it means that the client ends up with a better result that way.
Oh, absolutely. And like you just said, a client comes in, give me 15 minutes. Let me just fill out a couple of pieces of paper and I'll be out of there. Yeah, probably that's what a lot of people think, don't they, Megan?
Absolutely. I get calls all the time when I start asking questions and telling them about our process. They say, no, you're misunderstanding me. I just need a will. I just need you to plug in my name into a will and I'll just come down and sign it. Should be easy peasy, but that is not the way that it works, or at least not if you want an effective plan. It's not the way that it works.
And
Typically, my process occurs over 3 meetings, which is a lot of time together, but it's time well spent, and I think it really gives the clients who complete the process peace of mind.
Oh, yeah, to walk away with a really good, happy feeling, knowing that all that was done with your law firm that you are partners with. Megan, if you would please, your contact information again.
Absolutely. The phone number here at Blustein, Shapiro, Frank, and Barone is 845-291-0011. And our website is www.mid-hudsonlaw.com. And on that website is where you can sign up for those free workshops.
Oh, yeah. Which you do have one coming up, you said, in March, I believe, correct?
Yes. March 11th is the next one. It goes from 3 to about 5 p.m. I'll host it here at my office in Goshen. We have a really nice education center, like sort of a big suite. We try to have some coffee and tea available. Sometimes we'll bring in some cookies just to keep people satisfied while they listen to me for hours. But it's really solid information.
What about a steak and lobster dinner? Is that out of the question?
Maybe not for this setting. I think having that catered in would be not so delicious.
Of course, I'm just teasing, Megan. You know that. But
I do.
Yeah, people have to sign up for that workshop because seating is very limited. Correct?
It is. Unfortunately, while the room is sizable, sometimes we can't accommodate everybody. So the quicker you RSVP, the better off you're going to have at reserving that spot. And like I said, it's first come, first serve. It's absolutely free and available to the public. I do host these workshops every other month. So if for some reason the March date doesn't work out or it's already full, the next one that you can expect will occur in May. I believe it is May 21st would be the next one.
Wow. And, of course, these workshops run about 2 hours roughly?
They do, yep. It's a lot of information that we cover, and I try to leave a lot of time for questions because sometimes I think I'm conveying something fairly clearly, but it strums up a little more questions and concerns for the people that are attending, and so we will have time to chat during the workshop as well.
And it would be a good idea if people would bring a pad, a notebook or something, and take notes on this, right?
They're absolutely welcome to bring any materials. I do actually pass out a paper packet of the workshop that I'm presenting.
Oh, wow.
And there's room in the packet to take all the notes, and we, of course, provide pens. So even if you came, say, straight from work, you didn't have time to grab anything, I have everything you need.
Oh, isn't that nice? I didn't know that. That is great. That is great. So getting back to our conversation, how to avoid probate, is there anything that that has been left out with our conversation here?
I don't think that there's anything left out. Like you said, avoiding probate is pretty straightforward once you understand what probate is, what the purpose of it is, right, and which kind of assets it applies to. But while I want people to understand that they have this resource available to them, they can easily designate beneficiaries on most of their assets, and I think that they should, I also want them to understand that that in and of itself might not be a complete estate plan. It might not accomplish all of the objectives that you want, but it will certainly help you to avoid probate. So if there's just a couple of takeaways for people, I would say the first one is check on your beneficiaries. Maybe right now you're listening and you're saying, oh yeah, I know I designated beneficiaries years ago, but I want you to check on them because it might not be the beneficiaries that you still want. They may need to be updated. Sometimes a financial institution will lose the records of your beneficiary designation, and so they might have fallen off of the asset over many years. And then sometimes you think you designated a beneficiary, but maybe you never really got around to it, or if it didn't process for some reason. So I want you to check on those beneficiary designations. I want you to make sure that you have beneficiaries on your retirement account. That's a very important kind of asset to make sure you have beneficiaries on because the distribution is different if you leave it with no beneficiary versus with beneficiaries designated. So that's your IRAs, your 401ks, your Roth accounts, your qualified annuities. Make sure you do have beneficiaries on there. And then I would say don't stop there. Check in with an attorney to make sure that the beneficiary designation is sufficient or to explore some additional planning opportunities.
Wow. All right, so let's just say, hypothetically, you're in a courtroom, all right, for XYZ, whatever. And the judge says to the beneficiaries, all right, now the last will and testament is going to be heading into probate. Is there anything that you can do to stop that?
I think if the court has already determined that probate is appropriate, it means that there was already an analysis done to determine that there were individually owned assets at the time the decedent passed away, and now, unfortunately, we will have to go through that proceeding. Now, if it's a very small value asset, something under $15,000, sometimes there are some statutory forms, so paperwork, that we can use to collect those assets without going through the probate proceeding. So sometimes that's an option. If the total value of the assets that need probating are below $50,000, we still have to go through a probate proceeding, but it can be an expedited proceeding because the value is lower than $50,000. But then if it turns out that the value exceeds $50,000, we're going to end up going through that full probate proceeding.
Wow.
So your question was, by the time the court says, okay, we're going to enter into this probate proceeding, that usually means we've exhausted all of the other options for distribution, and now we need to proceed in that direction.
And that takes about how long? A year?
Usually the probate process takes about a year from start to finish. That would include the time it takes to prepare the paperwork that needs to be submitted to the court, circulated amongst the appropriate people for signatures, and actually submit it. Once that paperwork is submitted to the court has a lot of files that they have to work through. So right now we're finding our courts locally take about 2 to 3 months from the time they receive that paperwork to the time they actually appoint the executor. They say to the nominated executor, okay, now we're going to give you the authority to collect these items. So that takes about 2 to 3 months. Then the executor is tasked with going around and collecting the assets, which could take several weeks. The executor takes those assets and puts them into an estate account where they have to sit for a period of at least 7 months because creditors have an opportunity to recover any funds that the decedent owed to them. And they have a 7-month window to submit that claim. And then after the 7 months, the executor can distribute the assets and close out the estate. And they usually check in with the court at the 9-month mark to let the court know the status, if everything has been distributed or not. So several weeks on the upfront, then a couple of months for appointment, and then another 9 months before things can be closed out.
Wow. Oh, my goodness. Megan, our time is just about up, but again, if you wouldn't mind, please give us your contact information and how we can get a hold of you to make an appointment.
Absolutely. You can give me a call at 845-291-0011, and you can check out our website at www.mid-hudsonlaw.com.
All right. And, of course, your workshop, people just log on to your website, right?
That's right. You can enroll right through the website, or you can give us a call and we'll get you on the list.
All right. Megan, I hope you have an enjoyable weekend, a safe one, and let's pray for no more snow.
I'm praying with you, Bobo. Have a good one.
You too, Megan. Thank you so much. There she goes, an elder law attorney, and let me tell you, she is a megastar attorney. Really, give her a call and give her a chance, and I know that you're going to like her. All right, I'm Bobo. We're coming back to more of the greatest music ever recorded right here on Fox Oldies, 98.9, 105.3, WGNY FM in New York.